welcome everybody, and thank you for joining this seminar with the title Men Giving Birth to Children with Three Parents and Other Future Family Law Problems. And I fear I need to start with an apology, namely that the title is misleading because we're actually not talking about the future. We are talking about the present. Most of this lecture is actually based on my previous work, and particularly a book chapter called Breaking the Existing Paradigms of Parent-Child Relationships, published in a book called International and National Perspectives on Child and Family Law, Essays for Nigel Lowe, the wonderful family lawyer, and published by Intercentia in 2018. Right, and now to the lecture as such, and welcome to those attendees in right now. So family law, for a very long time, was almost exclusively focused on marriage. So children born outside of marriage were discriminated against, to put it tactfully. They were lovingly referred to as bastards, and in many countries, they didn't legally have a father. And in some countries, not even necessarily a mother. In some countries, the mother, even though she had just given birth, actually had to recognize her own child because of the nature of the way it was. So time precludes looking at these historical developments in more detail, but suffice it to say, once that particular issue was overcome, and there was general consensus that every child had a mother and a father, or more precisely, one mother and one father. Today, it is a fact that this is no longer so, if that ever was true, actually. So not only do the laws in some jurisdictions now accept three or more parents of a child, for example, in California, Ontario, British Columbia. Now, all around the globe, the two-parent paradigm increasingly is challenged, not only by societal changes, but also by medical advances. And jurisdictions will have to find a way to deal with these challenges. And it is for that very reason I suggest splitting the parental position into three distinct levels. I will return to that later. Now, why is this crazy Cambridge academic saying this? Well, because there are these challenges to the way we used to think about parents, and particularly the two-parent paradigm. So the first are societal changes. Perhaps more mundane one, although usually a very unhappy one, is divorce or relationship breakup. Now, not uncommon, of course, in this day and age, and when the couple have children, then the children tend to live with one of the parents, statistically more likely to be the mother than the father. But there may well be a new partner on either side, and they may be acting, certainly from the viewpoint of the child, as a parent for all intents and purposes. And the law then actually needs to decide which status to give to that parental figure, because obviously they're not the parent. I have a comment that somebody can no longer see the speaker's screen, which I cannot deal with, but hopefully somebody can. Right, so adoption is the next one, also already, from biblical times and before. The first legal texts we have actually allow for adoption. So adoption traditionally is the transfer of the legal position of the parent from one person or two persons to another. So we will have new parents, but what about the old ones? The nature of adoption has changed massively recently, and increasingly post-adoption contact and or information rights exist, so that the birth parents will actually have a keen interest to know what happened to their child. Now, traditionally, children were given up voluntarily. These days, that is not necessarily the majority of adoptions. So we are facing new issues here, and that is why the law on that has changed. In addition to that, we thankfully have a greater acceptance of so-called non-traditional family. And I now have a question about the slideshow. There is no slideshow. This is probably why you can't see it. I'm a very old-fashioned lecturer. I don't use slides. I just lecture. So that's totally arrogant, I notice. Anyway, it's probably also because I'm not very good with slides. Right. So, and I'm asked to speak louder, and I will. So we do have same-sex parenting in this day and age. We have rainbow families, we have trans parents, and intersex persons becoming parents. So the gender paradigm is good and well broken, but increasingly also the two-parent paradigm. In many jurisdictions, including the one from which I'm speaking, it is possible for a legal man to give birth to a child. And as was decided recently in this country, that nevertheless means that the person giving birth is legally determined to be a mother. So this country has recognized male mothers, believe it or not. Other jurisdictions have been even more strict and recognized the person in question only as a female mother. And all of that under the pretense of this being in the best interest of the child, which may well be doubted if the person who perceives themselves and presents as male has to present themselves as female when actually speaking about the parental link. And of course, we now have more and more jurisdictions where there is the possibility of a person not having a legal gender of male or female, but of course these persons can well be then parents. So the question really is whether we should subsist in using terms like mother and father. If we have same-sex parenting in this country, it's possible for two parents of the same legal gender to become parents. And should it not matter whether they're parents or not, rather than mother and father? And indeed, some jurisdictions have abolished the legal concepts of mother and father and are using parent instead, for example, Ontario, but also the otherwise usually rather conservative jurisdictions of Malta. And the idea behind this, of course, is the best interest of the child. In addition to societal challenges, we have medical challenges. So the traditional approach was that the person or the male person who is married to the mother is presumed to be the father of the child. Now that, of course, was a presumption in the age predating DNA testing. Today, we can actually find out. And we do. And there are actually surprising statistics on this. But if it later turns out that the husband is actually not the genetic father of the child, then jurisdictions have had to decide, although many actually haven't properly, who should be given priority. Is it the social father, the legal father at the moment, or the genetic father of the child? And here, the policy views are split. So in England, we tend to give priority to genetics, and that is because of our construct of parent responsibility. And in Germany, it is clear preference for the social existing link. And yes, there will be a YouTube recording available from October on of this. I can answer that. Right, so we need to decide in this particular situation, who do we prioritize? The social father, the person who does the fathering, or the person who is the genetic father but may not have been involved yet and may actually not want to be involved. Then we have the good old adage of mater semper certa est, meaning we always know who the mother is. But actually, do we really? We live in an age of egg and embryo donations and of surrogacy. And again, jurisdictions need to decide what to prioritize in these particular situations: gestation, genetics, intention. And I recently published a major comparative study on this called Eastern and Western Perspectives on Surrogacy, and you can see that the answers differ significantly. So for children conceived via artificial reproductive techniques, when we're using donated genetic material, including mitochondria, it may well be the case that the donors do not want to be involved, in which case we may or may not have a problem with the allocation of parenthood, depending on the way the donation was administered. But we also have known donor cases where there may well be a different view, where the person who is the donor would like to have an active parenting role. And that is actually intended by all the people involved. And that may be more common in rainbow families, but it's perfectly conceivable that, for example, a husband and a wife are desperately trying to have children. It's not working. They found out that this is so because the husband's sperm is tired, and that is a technical term. And so they decide to go for donor sperm. And when contemplating this option, they're speaking to the brother of the husband, and they realize that if the brother of the husband donates his sperm, then there will be at least a 25% chance of genetic link between the person who intends to be the legal father, because of the way genetics work. So they're thinking about using the brother's sperm, but the brother says, that's all good and fine, but of course we're a family, I will see the child all the time, I do want some kind of link as well. And this may actually be a reason potentially to rethink these things. And this may actually be more common than we think. And add to that, in particular, the desire and indeed the right of a child to know their genetic and biological origins. So we also have other situations where we have mitochondria donation. So we do actually have the possibility, and this is performed in the United Kingdom, but also in the United States, where the mother suffers from a specific mitochondrial disease, that a mitochondria donor is used and found, the mitochondria exchanged, and technically that means that this child has 3 genetic parents. That, of course, is a very specific case, but it just goes to show that genetics doesn't necessarily have to determine everything. And, of course, we have surrogacy, as I already mentioned, which is already in the Bible in Genesis 16, from 1 to 16. You can find the first case of surrogacy. That was a traditional surrogacy. Today, we are more faced with gestational surrogacy, meaning that the woman who carries the child is actually not genetically related to the child. But I maintain that her contribution to bringing the child into this world is a fundamental one, and that this role perhaps ought to be recognized, not least for the benefit of the child, who may well wonder later in life when they're learning about the way they were conceived and born, who the person was who actually made that particular contribution to their existence. Now, I said we need to split the legal position of a parent to different levels of parental links. And I call them parentage, parenthood, and parent responsibility. So we do have differentiations like this in a number of jurisdictions, but what we do not have in most jurisdictions is a coherent and structured approach that can accommodate the full range of modern family forms. And therefore, I maintain that we need to have these 3 distinct levels, and they build on a terminology coined by my former colleague Andrew Bainham, but I kind of go beyond what he originally said, and it's parentage, parenthood, and parent responsibility. That is beautiful if you're doing this in the English language. If you're doing this in other languages, it's much, much more difficult to replicate this, and I acknowledge this. So very often this is substituted for a legal parenthood, social parenthood, and biological parenthood, but I will come back to that. So I will run through now with a brief explanation of what these things are, and then an application of them later, and see how this works in practice. So for terminology, so parentage is the term I use for the purely biological link to the child. And please note, I'm not saying genetic. So for example, an egg or a sperm donor would have parentage, as would, of course, the birth parents of a child who was adopted. But in my view, this is not just about eggs and sperm and genetic contribution in the narrower sense. I would include other forms of biological links, and therefore include a surrogate, and of course also donors of mitochondria in this particular category. Now, why am I saying this about surrogates? Well, we may think about surrogacy what we want, but I think we can agree that a surrogate is certainly more than just the womb. She contributes much, much more. She carries the child, she shares her body and her antibodies and so on. She makes a very significant biological contribution to the birth of the child. And I have been told by my colleagues in the medical department, that's what happens when you go to a Cambridge lunch and start talking about your work, that you can actually identify surrogate mothers through testing and comparing the antibodies. And for donors of mitochondria, the argument for this is even clearer, as their contribution actually is a real genetic contribution. So parentage is what I would use for advocating a biological link. Now, parenthood, perhaps slightly more simply, parenthood is the term I would use for persons who are by law declared to be the parents of a child and with whom kinship is established. And this would, for example, be the couple who conceived a child through artificial reproductive techniques or the adoptive parents. And this is often also referred to as legal parenthood. Right. Parental responsibility, as the third term I'm using, and in many ways on the lowest rung of the three, is a term that I use for a person who legally is permitted to exercise some, many or all of the functions traditionally associated with being a parent, that is to take decisions on behalf of the child, other terms and statutes very often used around the world are guardianship or custody or parental rights, to make it even more brutal. But what matters for the way I use the terminology is that holders of parent responsibility are permitted and in many instances legally expected to actually do the parent. Right. So my general thoughts on the application of this split parenthood position. Now, for the vast majority of cases, parentage, parenthood, and parent responsibility will be vested in the same person. So it will not make a difference for most people at all. It's an extremely useful distinction to make in cases where there is a need to distinguish between different layers of what I call parental connections to the child. So to give you some ordinary examples, in adoption, the adopters will obtain parenthood and parent responsibility for the child, but the birth parents would retain parentage. Another example, remarriage of, let's say, the mother. So in many jurisdictions, the new husband can obtain some form of parent responsibility, while the former husband and genetic father of the child retains parentage and parenthood, and often also parent responsibility. I'll come back to that specific constellation later. It's very, very common. But you can see that even in these, what may be perceived as ordinary cases, the terminology at the splitting of the parental position helps to clarify the link that each person has to the child. But the problem is that in many jurisdictions, what I suggest splitting into 3 levels is actually linked by using the term parent. So in most jurisdictions, there's a very hard link between parenthood and parent responsibility, because in most jurisdictions, being the legal parent, i.e. having parenthood, is a necessary requirement for full parental responsibility. But by merely declaring a person a legal parent and then let all consequences flow from that, to me, would negate the links a child may have with other persons. It might simply not reflect the lived reality of the child and the other persons involved. Now, children are not lawyers, and that's a good thing. Children just call persons mummy and daddy who they socially perceive to be their parents. Children are not lawyers. They express their feelings, their love, their affection for a person using these terms. And these feelings are not necessarily restricted to 2 persons at all. I know quite a few people who have a mom and a dad and a daddy. And as you may guess, one of them is the genetic parent and the other is not. But from the terminology, you could not guess who actually is more important in the life of the child. And they may be equally important for all we know. So I would suggest that there is no logical necessity that the different parental positions, once recognized as such, need to be restricted to 2 persons on each level. On the contrary, I would think that the whole point of thinking about splitting the parental position is that different lived realities can actually be accommodated within that. Now, crucially, I'm not a legal imperialist, so I would argue very strongly that each jurisdiction could and indeed should decide, based on the distinctions made, which legal consequences, if any, are to flow from holding parentage, parenthood, and parent responsibility. So it may be most common that parentage will actually have very little, if any, legal consequences. So let's think about that a bit further. So parentage, as I said, would reflect the biological link between a person and a child. And this would mean that the donors of gametes and mitochondria, and as mentioned, surrogates, would also fall into this category. This would expressly recognize the genetic and gestational contributions of the persons concerned, and therefore this can, by definition, be more than two persons. Other than being recognized as having parentage, no immediate legal consequences need to flow from this, and actually would assume that normally is the case. But it would establish and make available, particularly to the child, information on their biological origin, while at the same time drawing a hierarchy and making clear that the other parental functions, parenthood and parent responsibility, are taking priority regarding the child. But having parentage could become legally relevant if, for example, if we choose to do this. Yeah? So if, for example, the only persons with parenthood and parent responsibility, probably the legal parents, die in an accident, then the person having parentage could, if appropriate under the circumstances, be among the group of people to be considered for a more active role in the life of the child and potentially acquire parenthood and parent responsibility if and only if this were in the best interest of the child. I'm not saying that we have to do this, but I'm saying it will enable us to think about whether we think this is appropriate. Another example, if a person holding parentage dies and leaves no heirs, normally this money would go to the state. But we could decide, for policy reasons and actually for consistency reasons in succession law, decide that the child will inherit from the person who has their parentage, rather than the estate falling from the state, falling to the state, because they may actually have a better claim, and it's the genetic or biological lineage and so on. I'm not saying that we should do this. I'm just saying we would and could do this if we wanted to. Or we could actually enable persons who are holding parentage, like adoptive parents, for example, under certain circumstances, make them entitled to receive your regular updates, for example, an annual update on the child, including, for example, a picture or just a short report on how they're doing. To bring in a personal example, so a friend of mine decided to give up her child at a very early age when she was in no position to raise a child. And that was the most painful decision, she says, she ever had to take in her life. And not a single day goes by that she actually spends thinking about the child that she actually never raised. So one could argue that here, being able to sort of access some kind of information on the child would actually be beneficial for the person bringing up the child. But of course, more importantly, and we should be focusing on the best interest of the child with all of this, the child would be in a position to access this information. The child would be in a position to know about their biological origins. And we do know for a fact, and we have massive studies from adoptive children, but we also now have an increasing number of studies regarding children conceived through artificial reproduction, that some people quite rightly have a deep desire to know where they're from. And unless we are consistent in recording parentage, we may not be able to do so. Right, parenthood, so the second level. So I say that parenthood should be allocated to those persons with whom the child is meant to have the closest legal links and established kinship. As is already the case, this can be utterly and totally independent of any biological link. And because that is so, there is no logical reason to restrict parenthood to two persons unless we have a good policy reason to do so. Because the legal position of being a parent in virtually no jurisdiction on the planet is by necessity tied to a biological link. And indeed, we have some international examples for the recognition of multiple parenthood. In California, section, and I'm not making the number up, 7612C of the California Family Code allows courts to recognize multi-parents if the recognition of only two parents would be detrimental to the child. And it is then stated, and I have to read this out, in determining detriment to the child, the court shall consider all relevant factors, including, but not limited to, the harm of removing the child from a stable placement with a parent who has fulfilled the child's physical needs and the child's psychological needs for care and affection, and who has assumed that role for a substantial period of time. And if you then look at the explanatory notes of the bill, which is always a good thing if you're a lawyer, then it says most children have two parents. But in rare cases, children have more than two people who are that child's parent in every way. And it is the intent of legislature that this bill will only apply in the rare case where a child truly has more than two parents. So in short, and to categorize, in California, multiple parenthood is possible by court order, based on actually assuming a parental role, based on actually being an active part of the life of the child. So it's parenting by doing. In no way is a genetic link required. And we need to think as societies why we would value a genetic link over and above a social link in some situations. Right. By contrast, in British Columbia, so slightly further north, multiple parenting can be regulated by the potential parents themselves, but only in cases of artificial reproduction. So Section 30 of the Family Law Act of British Columbia permits agreements between potential parents on parenthood in these cases. No specific genetic or other ties are required, but the agreement needs to be made in writing before the birth, and the birth mother, so the person giving birth, must be one of the designated parents. So here, multiple parenthood can arise in the context of artificial reproductive techniques as a result of the intention of the parents embodied in the written agreement. Again, no genetic link is required. I'm not advocating any of these models, by the way, and I'm not saying that I agree. Actually, I more than slightly disagree with the British Columbia model, because there's no consideration of the child's welfare in this particular context. So I could just go out and agree with the most horrible people that they want to be the parents for all sorts of reasons. So there are various, and Ontario's law, and we could go through all of these, but we're talking about the principle here. So, but the advantage of allowing multiple parenthood is that it enables the law to accommodate the multitude of modern family constellations, not only so-called rainbow families, but also in all sorts of other cases, in case of divorce, of remarriage, in cases of artificial reproductive techniques, where we have known donors and they would like to be involved. And if the position of parenthood is contingent upon it being in the best interest of the child, this may well be a sufficient safeguard to protect the children. And this approach can be used to recognize both biological and social connections to the child, and crucially also increases the pool of persons with legal responsibilities towards the child. For example, with regard to maintenance or succession law. And those, of course, can be crucial. Now, there's a disadvantage. That may be that we may have to distinguish between different holders of parenthood. For example, giving those with whom the child physically resides, if they don't live together, greater rights and duties. So inevitably, there will be conflicts between holders of parenthood, and they will have to be resolved. But that is not an unknown. The law has been dealing with cases like this for decades, and more or less well in various countries, but it is something that we could do. But actually, if we're allowing multiple parents, that throws a further question mark on the terms of mother and father, and perhaps they should be abandoned in favor of the legal category of parent, which in a world of increasing gender equality, as well as same-sex and trans parenting, is the right way to go anyway, in my view. And it may surprise you to hear that my daughters, who happen to be 6 and 7 years old, and may I be watching this downstairs, have never ever asked me for their birth certificate. So they have never seen written proof that I am their father. And, you know, for all I know, you know, the information recorded is correct. But, you know, anyway, guess what? They do call me daddy anyway. Why do they call me daddy? Because I am their daddy, and I act like their daddy. So if we abolished the terms mother and father, nobody would take daddies and mummies away. The terms mother and father would live on perpetually and forever in the social sphere. It is just the legal term of parent that we would abolish. The legal term of mother and father we would abolish in favor of parent. And I would just be as much as a daddy if I was recorded as parent too on the birth certificate. So I am not afraid of that change. As I said, Malta and, for example, Ontario have gone down this route, and Malta so far has not sunk into the ocean. So everything seems to be going well there, and no problems have been reported. Right, now the third and final level is that of parent responsibility. Now, in most jurisdictions, England, Wales, and Finland being notable exceptions, full parent responsibility can only be held by two persons. Now, I could give a full seminar on that alone, so I have to restrict myself a bit on this here, given the way time has progressed. In some jurisdictions, some minor form of parent responsibility can be held by additional persons. So, for example, in Germany, the kleine Sorgerecht, but not full parent responsibility. Now, jurisdictions operate on this because they have this underlying assumption of two persons, two parents. Because every child only has two parents, right? But we know that this day and age, this is no longer true. And socially, it actually never was true in the first place. But crucially, the limitation is so strong that in all jurisdictions bar England, Wales, and Finland, if another person, say a step-parent, is supposed to acquire full parent responsibility, somebody else must lose their parent responsibility, and that will usually be the absent parent. So you can imagine how this actually intensifies conflict. First you steal my wife, now you steal my children. In England and Wales, we have a very different approach to this. I sort of tell to my students the language that they appreciate. I will say, you know, whenever this arises, English law says, chill. Nobody needs to lose anything. You can have parent responsibility as well. Everyone happy? Good, let's move on. Because in England and Wales, we can actually have multiple holders of parent responsibility. And the clue, of course, is in the word. It is parental rather than parent responsibility. I could go on about this for a long time, and by all means, do ask me about it. I love talking about this, but let's focus on the lecture for now. So, irrespective of all the issues raised by artificial reproductive techniques and so on, and the categorization of parental links here, we should ask ourselves, why on earth, in most jurisdictions, are we restricting ourselves to two persons? Why can there not be three or more? You know, giving them parent responsibility does not make them parents. They don't get parenthood. The term is parental, not parent responsibility. To me, this seems a much better approach. It can be enormously useful in diffusing family conflict situations in case of remarriage and the new partner wanting to be the real parent. As I said, if you only have it for two persons, that means one must lose out. And conflict is always detrimental for a child. We can avoid this conflict to a large extent by actually giving the new partner parent responsibility as well, without extinguishing any of the existing parent responsibility. Of course, providing there are mechanisms in place to deal with disagreements between the various holders of parent responsibility. And such mechanisms are and have been in place in all jurisdictions. And again, the English approach actually has much to commend it. Another example we can think of, and that actually happened in my family as well, I'm full of private examples. So when the husband and the wife are offered amazing job opportunities in Saudi Arabia, and they decide that perhaps it is less than ideal for their 14 and 16-year-old daughters to come with them, and they would actually be happy for them to live with their grandparents. But if they're in Saudi Arabia, you know, somebody needs to take the day-to-day decisions regarding the children and all of this. And in England and Wales, we have a very simple mechanism by allowing a court order that will actually give these grandparents parent responsibility as well. And suddenly you have 4 holders of parent responsibility. And that's not a problem for English law at all, and we can deal with these things relatively straightforward. Now, an approach focusing on the allocation of parent responsibility could also be applied to other situations, particularly those created by artificial reproductive techniques. So because it allows a person to assume a parental position without actually becoming a parent. So no parentage or parenthood. We're just talking about parental. But parent responsibility is probably what matters most in everyday life, because it enables you to take an active role in the life of the child. So when a jurisdiction is unwilling to accept multiple parenthood, and there may or may not be good reasons for that, then to a certain extent, we could accommodate modern family forms by at least allowing multiple holders of parent responsibility, as we do in England and Wales. Now, the main disadvantage, of course, is that people who are merely given parent responsibility will, of course, feel inferior because it's not the same status, not the same as real parents. There is something to this, of course, but if parentage and parenthood increasingly matter less and parent responsibility increasingly becomes more important, this may at least mitigate this concern or perception, and it also depends on what we actually do with parent responsibility. So, to conclude, you will be relieved to hear, we need to ask ourselves, what really makes a parent? Is it the mere genetic or gestational contribution? Is it the mere legal position allocated to a person? Or is being a parent actually about being a parent, doing the parenting on a daily basis, raising a child? Is it not the latter that really matters for the child and for society as a whole? I hope I've shown that we are facing quite a few challenges arising from societal changes. My voice is facing some challenges as well, as you can hear. From societal changes and medical advances, the problems are not insurmountable. And we do not have to reinvent the wheel. On the contrary, the tools we need actually are in our toolbox already. We just need to think about new ways of using them. So what used to be legally combined in the term parent needs to be split up into 3 distinct legal levels: parentage, parenthood, and parent responsibility. Now, as I said, normally these 3 categories will be vested in the same person, so the technical legal split would actually not to an actual legal change in the position of most people. However, distinguishing between these various forms of parental links allows us to deal with other situations that, while no longer extraordinary, still are the exception and not the rule, at least. Now, which persons and how many should be allocated the legal positions of parentage, parenthood, and parent responsibility is a policy decision that every jurisdiction needs to take for itself. There cannot be universal answers to that question. Each jurisdiction, each country has their own legal traditions, their own societies, their own social structures. But that said, in my views, societal changes and medical advances not only necessitate the split of the parental position, but also, and more importantly, the positive recognition that each of these legal positions can, and perhaps in some cases should, be held by more than 2 persons. Because that, and only that, may reflect the way the child lives, the lived reality of that child. And if we put the child at the center of this, I think we owe it to the children to recognize the parental links that each and every one of them have. Thank you very much. I'll take a short watering break and then I will start looking at the questions. And I can see most of them tend to be rather long. It's much easier for me if they're short and snappy. But I will do my best. So I have a question on, most of them seem to be on surrogacy, interestingly. So I have a question on whether I believe there's a practice of gender discrimination in the treatment of intended parents in the case of surrogacy. And yes, absolutely. So that also forms part of the book that I mentioned previously, Eastern and Western Perspectives on Surrogacy. And it is usually a discrimination of female infertility issues that we see there, because the male person will be usually recognized if they made a genetic contribution in some shape or form, but the genetic contribution of the woman will very often be neglected and not given full legal effect. I have a question, why not recognize a trans man who gives birth as a father? Yes, I would be fine with that. That is, for example, the solution that they're aiming for in Sweden. Although in my ideal world, we wouldn't have the legal term of father anymore. But nor would we have the term mother, they would just be recognized as a parent. But I would certainly think that it is more appropriate to recognize them as the father rather than the mother in this particular context. Long question, trying to read it. Whether we should be doing more on protecting children from misattributed paternity. Well, arguably, the UK already does more than many countries, because you can actually have, if there's sufficient suspicion, a genetic test to prove paternity. In this country, much more than you can in others. So globally speaking, we're probably doing more than most. But of course, we cannot go as far as mandating tests for every child that is born. I think that would be taking it so far. But I do agree that the UK system, or the English system of birth registration, is in need of an overhaul, as many registers, one might argue. Scrolling up. Yes, so there's a question on whether, if we replace the terms mother and father, would affect the family court's preferential giving of custody of children to women, and then formerly mothers. Well, there may or may not be that particular bias in the courts, and that's a different discussion to be had. But I do think, detached from this question, that if we actually lose the terms mother and father, there would be hopefully a positive development with regard to the expectations performed by the parent, the expectation of the roles performed by the parents, and so on. So that there wouldn't automatically be the same assumptions in place that may or may not be there today. And that may be wishful thinking. But I mean, we have evidence that changing legal terminology actually makes a difference in the long run. And there's a good example for that, actually. So in Denmark, the term of parental custody, to translate it roughly, was actually replaced with parent responsibility. And the reason why that was done is because this should actually be about being a responsible parent and not about some kind of power of parent. So the idea behind this was to emphasize that actually, if you're a holder of parent responsibility, you do have a responsibility for that child. And interestingly, this has changed, according to some evidence, the way conflicts are dealt with, or as one judge has put it to me in a different context, if you're talking about parental rights, you very often will have people in the courtroom banging their fists on the table and saying, but I have a right to this. And he said he found it very difficult to believe that the very same person would bang their fist on the table and saying, but I have a responsibility for this. So that may well give it a different slant. All right, let's scroll. There's questions coming in. I don't want to discriminate against those two. Those asking later than earlier. I have a question on whether sperm donors who may father multiple children, what are their rights? Well, that depends on the jurisdiction, but it also depends on the way the donation actually is created and applied. So, for example, in England and Wales, the fact that you're a sperm donor, and if the donation actually comes through the or the child is conceived according to the procedures under the Human Fertilization Embryology Act, then the sperm donor has precious few rights, and that may well be appropriate. But there is a register, so the children can actually identify their donors if they want. Whether we want to extend these rights, of course, is a policy question, and I apologize for my voice fading. I just received the test results today, so I'm doing surprisingly well. We need to think long and hard about whether we want to allocate rights to pure donors. And the answer in most cases may well be no. But of course, we have to distinguish between known donor cases and unknown donor cases, and that may well be different. Scrolling up, let's see. There's a question about inheritance of illegitimate children. Well, the reason, I mean, this is not a succession law seminar, but I do mention it because I think it's a very important right that the child may have. It is certainly of lesser importance now than it was, because in most jurisdictions, it doesn't really matter whether you're born inside or outside of wedlock, and that's how it should be. And indeed, we do have European court cases, like it or not, that actually say something along those lines. Some jurisdictions have taken much longer than others to realize this. So for pure inheritance purposes, it doesn't really matter whether you're born inside or outside of wedlock for the most part. And therefore, this is why I sort of just gave it cursory mention, but I did mention it when we could enlarge the pool of possible people from whom a child could inherit. So in case of multiple parenthood, this would of course automatically ensue because you do inherit from your parents. Whether we want to extend this to specific cases, as I mentioned, in the absence of any other heirs, for example, in the case of parentage and so on, that is something that we may want to consider as a society, but that's a question I haven't thought about really deeply. Right, let me see what else there is. I'm beginning to lose participants. That's never a good sign. Right, this is a longer one, apologies. Right, so this is a question about a person who was adopted and had difficulties and actually never managed to trace back their birth parents. Now, hopefully in modern societies, there will be some kind of mechanism of identifying, there will be a legal paper trail or computer trail these days, where people can identify their birth parents, and so that may be a specific problem of the past. But the second part of the question is whether we see a narrowing of this and a sort of sharper move towards more traditional perceptions of family, and that is certainly true in some jurisdictions. We see movements in that direction, but on the whole, globally speaking, I think the move is in the other. You will always have counter moves as well. But what I would say in these situations is that we as a modern society should really put the best interests of the child first. So whether or not you approve of same-sex parenting, frankly, is neither here nor there if we find that it is essential and in the best interest for the child to actually have that legal link. Because if you don't recognize the second parent, then you're depriving the child of maintenance rights, you're depriving the child of succession rights, you're depriving the child of a very meaningful and important legal relationship that may well have social repercussions. And I do think that is highly inappropriate if we actually value the child for as is, because essentially we are transferring our potential disapproval of the adult relationship onto the child. So I'm an advocate of a child-centered family law anyway, so that won't surprise you. But I think we do need to put the children first. And yes, according to the belief of some, the only acceptable family form is that of a marriage of a man and a woman in marriage, and that may well be the norm. But we need to accept that even where this is disapproved of, we do have, we do have people living in a different way. And while I personally, as you have actually, if you've looked at any of my work, you will have seen this, because I would advocate the recognition of the adult relationship as well as a bare minimum. We owe it to the children to recognize the parent link and give them the rights that they deserve. Now I see a question from a former student. Hello. Lovely to read you, that is. Are we moving towards recognizing multiple parentage, i.e. more than two parents? I don't see anything happening on this in England and Wales at the moment. I mean, we are, with regard to parent responsibility, and I said that's a very different seminar, we are fairly much ahead of the curve. So we can actually have recognition of familial structures, of parental structures to a larger extent than other jurisdictions can, because we do allow multiple parent responsibility. And that is full parent responsibility, not joint and not shared, it's full, individual and full. But I don't see any movement towards multiple parenthood. Right, I think my voice is giving, two more questions that I see here. So would the term be better than father, as it also recognizes those who identify as being gender neutral? Absolutely. This is another reason why I would advocate this term, because the terms mother and father are invariably gendered. And I think it is inappropriate to force that kind of gendered recognition on a person who identifies differently, and that also applies to the transparent, of course. And that's that. And of course, the final question that I kind of was expecting, so recording parentage in the context of rape, and particularly where there's no criminal charge or that may not have been successful. That, of course, is a very specific issue, but if you take the position where, a genetic test can be made, or there's no, or it's not being contested, then of course we would recognize the parentage of the perpetrator, but I sure hope that we wouldn't give them any rights for anything, and that of course can be done as well legally if this is the construct that we want to have. Now, if we cannot establish that, that then of course is a more practical problem, but I fear that texts are off. Right, I'm sorry, I think I'm giving up now. As I said, I've recently risen. Thank you for your attention. It's been lovely to have so many of you here and to have an interest in family law. I hope you enjoyed this a little at least, and that you will enjoy the rest of the Alumni Festival. Thank you very much.